For Every Bright Idea, the new podcast from the Business and Intellectual Property Centre in Norfolk. In this series of podcasts, we're going to talk about some of the business issues affecting Norfolk and the surrounding areas. My name's Pete Golland, and I'm the BIPC Coordinator for West and North Norfolk. And with me today is my colleague Johnny. Hi, Johnny.
Hello, hi everyone. My name's Johnny. I'm the BIPC coordinator for Great Yarmouth and Broadland.
Hi, well, good to have you on board today. So the IP part of the BIPC refers to intellectual property, and intellectual property is the overall term for protecting your creativity and innovation within your business. We run some IP one-to-ones at the BIPC, but today we're lucky we've got a real expert with us. We have Melanie Harvey, who's a chartered trademark attorney for Burkitt's LLP, and she very, very kindly runs some free IP legal sessions with us. Hello, Melanie. Nice to have you with us.
Hello, Pete and Jonathan. Very nice to be here. Thank you for asking.
So really, I think what the question, this sounds like a devastatingly simple question, but I know it's not. What exactly is IP, and what are the different types of IP that you actually work with the businesses?
Oh my gosh. I mean, it's a catch-all, intellectual property. It's pretty much anything that is an intellectual creation. I mean, that's it in a nutshell. But the types that people will have come into contact with or have heard or have read in the newspapers are things such as patents or inventions. You've got trademarks that cover your branding. You've got designs that cover the shape of things, the appearance of things. Copyright is the one that quite a lot of things fall into because it's a very specialist form of unregistered right, but again, covers the look, the appearance of things, but it's also literary, artistic, dramatic and musical work. So it's a really big catch-all on that side of things. Confidential information to a degree is intellectual property, as is know-how, and the list goes on really. But the ones most people are aware of would be patents, trademarks, copyright and design.
Okay, well, that's really interesting. I think later on some of these podcasts we'll go into some more detail about individual ones. But I think some of the other things, what would you say, Johnny, about the importance for business?
Yeah, so like when a business thinks of intellectual property, and I think a lot of, especially startup businesses, they may not be too aware of IP and how to protect it. Should it be something that early stage businesses should be thinking about, or should it be later down the line in your experience, Melanie?
Well, I think it really depends on the particular type of IP. And I say that because if you're considering trademarks, which is the core 120 business, it's your brand identifier, it's who you are, it's your product. So it's really, really important. That one, you can, as long as you've done your due diligence and you're not treading on any toes, you can actually use trademarks in their unregistered form until you're ready to push forward and get proper protection under a registered trademark. Patents, you don't have that benefit because if you've got something that's patentable, it's an invention, it's new and it's inventive and it's way different to anything that's ever been out there before, you have to have absolute novelty. So you can't have put it out into the public domain. All conversations have to be under the veil of confidentiality, non-disclosure agreements, so that it's kept private. And that's a good way of ensuring that if you have got something and you've done those kind of preparations, you're not actually going to negatively impact your own sort of way forward by actions you've done. So that one, you really have to be completely out of the public domain before you get something on file. But for the patent side of things, that's the key thing. It's your filing date that's really important because then everything starts flowing from that. Designs is a sort of middle ground because you get the option of having a 12-month grace period. So for that, because it's the look, the appearance of something, the IP offices are aware that you're only really going to want to protect something that's going to turn out to be valuable to you. And so you're not really going to know whether that's of value until you've put it out there. And so you've got a 12-month period from first going live to seek that type of protection if there's sufficient take-up, which is quite nice. And copyright is automatic as soon as you fix it. And then it's just the only thing that differentiates them further is the duration of each right. Trademarks can live forever. You renew them every 10 years. Designs are a maximum of 25 years. You do it in 5-year chunks. Patents are a maximum of 20, but they are the gold standard. If you've got something that is a patentable invention, that's where all your focus needs to be because you have to get it on file, you can't disclose. And then at that point, you can think of all the other forms because most of them interlink. And I tend to sort of describe it pretty much like an onion. It's all different layers. And so it's the timing that's right for your business. There is no answer that is the gold standard that everyone should abide by, because everyone's situation is different.
That's interesting, because we deal quite a lot with trademarks and
Yeah.
designs, don't we, Johnny? I think that's our bread and butter, and it is. I don't want to say it's simple. It's relatively simple, isn't it? It's a straight to actually check the trademark database and design data. That's actually relatively straightforward for a business to do. It's the patterns that always scares us. I don't know about you, but it's a bit, and for
Patterns aren't
customers
so
as well. I
bad. The
think they're very
difficulty-
intimidated by it.
Well, the thing is, you can check that. You can go onto a SPAS, the database run by the EPO. The problem is patents aren't published unless they're accelerated. They're not published until the 18-month mark. So you've got that big grey area. You can be doing something, you can have done all your searching, and you'll see everything that's visible. And by visible, I mean everything that's published. And so you never know when you're filing if you truly are the first one across the mark. And that's why it's really important on that aspect to actually get something in file, because as long as you've got your invention and enough sort of built in that you know what your core part of the invention is, and then you add these extra layers to support it. And the idea is your patent is a working document from the moment you actually file. And so it will be examined, you might have to rejig, you might have to alter the priority of your claim so that your primary claim is still new and inventive over anything that the examiner might bring forward in the examination. But you continue to do that through the lifetime of your patent. Even after grant, you can make amendments as well.
Yeah, that's a really good way of thinking about it. Yeah, it's also cost-wise as well, because I think some of our startups and businesses are a little bit, again, with design and trademark, we're on safer ground because the costs are quite fixed, aren't they? But the patent can be a bit more.
I think the real problem with patents, and don't get me wrong, you can self-file.
Yes.
And the IPO is very, I mean, whatever form of IP you're seeking, if you're doing it yourself, they will be incredibly supportive. They've got a lot of literature on their website, but individually, they are very supportive. The reason most people are put off on the patent side of things is when they do their searching, the language is very defined, it's very weird. It usually talks about limbs, and it's just the way you compartmentalize it when you're describing things. But the reason it's so expensive is most people will seek a patent attorney out to actually help them, because the reason you pay them the big bucks is it's the claim set at the end of the application. There's different parts. So there's the title, the abstract, then there's the description, then there are drawings. But the very last element of a patent application are the claims. And they are really, really important, because this is the part that defines your invention. And this is the part that once you've got a grant, if someone else, whatever they're doing, can be read onto one or more of those claims, then you're touching on potential patent infringement, possible licensing because it's without your permission. So there's lots of actions that can then occur. But even if you do the majority of it yourself, most patent attorneys will do something called inventor's notes, where the inventor produces most of the things. And so all you're really liaising with the attorney about is the claim set. And that is somewhere I highly recommend that you spend the money, because that is what's going to take you through, get you your grant, and also through the 20-year lifespan of that grant will ensure that you're in a really good position.
Right. Okay. So could you just explain a bit more about the claims? Could you just explain a bit more about that? Because you said about.
Yeah, because I mean, it's very archaic when you read the claim set. It's the section right at the end of a patent application, and they're usually numbered. I mean, it's not uncommon to have a minimum of 5, but depending on the invention, you can have as many. But the primary claim, the very first claim, has got to be, in a nutshell, everything that is your invention. So it's the minimum number of components, it's all the elements, but the minimum. And then the layered approach, where you come down, because you'll have dependent claims, it will be the primary claim plus another feature. And the idea is you start embedding all of those additional features so that your working document has that ability to change. So you go through, you file, you're examined, an examination report is issued from the UK IPO. They'll set a period of time to respond. And what you usually have to do is defend against any sort of query of your novelty or your inventive step. And so when they cite earlier sort of filings, they do naughty things, they mosaic, and they pick aspects from lots of different ones and say, well, you can't possibly have novelty because of all this. No, it has to be in a single document to be destroying of what you're putting forward. And so what most people do is they look at what's being brought forward and they say, right, have I got a point of novelty, because that's the minimum that's needed. Inventive step tends to be argument based anyway. And so you juggle. You see what features you have in reserve, and then you elevate them into your primary claim to make sure that that primary claim is still novel. So that's your working base. And that's why that claim set is really, really important, because that is something that you can do, but you're not used to doing that sort of thing, whereas patent attorneys will be looking at all those angles and thinking.
I think we'll come back another podcast and talk a bit more about patents, because it's an endless subject.
Yeah, I was just going to ask. So, just in terms of patents, very quickly, talking about the patentability of it, is it the novelty and the inventive step that are the two key components to that, and that's what the examiner will be checking?
There are 4 criteria, really. The main one is it has to be new. So novelty is it just has to have a point of difference with something that's already gone before. Equally, you will get novelty if you pull together lots of known components, but in a different way. So that's how you get novelty. Inventive step is the next hurdle. And that's essentially looking to underline that it is an invention, that it's not just the next evolutionary step. There's something that's happened. There's a leap. There's this big move. And that's why you're entitled to this monopoly right as a result. The third one is the one that most people get instantly, and it's the capable of industrial applicability. And essentially that just means it can be made. So I'm sorry, perpetual motion machines can't be made, so that's never going to win.
That is important, because ideas in their own right can't actually be patented, and it has to be something that's practical.
Something that ultimately you can make. I mean, you can do a conceptual patent, but there's an outcome that you can actually follow the guidelines. And the fourth string tends to be it's not part of the excluded matter, because the UK Patents Act has a whole list of what can't be done. So software per se can't be patented, but that's okay because that's covered under copyright. You can have at the core of your patent software, but you're not protecting the software. You're protecting what the software is achieving for you. And so that's why that's okay. Methods of doing business are problematic. You can't have those. Medical inventions, can't have those either, but that's sensible, because the last thing you want is someone on an operating table and someone going, actually, you can't use that. And it has a very sort of hazardous impact on the person on the table. So there's all reasons behind what they are, but you can usually, with the help of a patent attorney, assess where you fall and maybe what additions you need, or possibly you've even got multiple inventions and you can decide the priority of the ones you want to go forward with.
That's interesting. I mean, I think we can sort of like trademarks and designs and patent sort of measurable. I think copyright is one that often confuses. We deal with quite a lot of creative people and artists, and they find copyright sometimes a bit difficult to sort of get their head round in one way.
Oh, I think we all find copyright difficult to get our heads around. Well, it's nebulous. It comes into being as soon as the qualifying work is fixed, and so pen to paper, your drawing is fixed. And so it tends to, on the whole, be the lifetime of the author plus 70 years. And there's a whole sort of stream of consciousness when it comes to who is the first author, who is the creator, who actually gets the rights to copyright. So that's the first hurdle. The second hurdle, well, actually, no, that's the second hurdle. The first hurdle is it a qualifying work? There's a whole list of works that are covered by copyright. And the 4 main banners are literary, artistic, musical, and dramatic. I mean, there are a few other ones that are in there, sort of database rights and various things like that. But the majority of them are under those 4 pillars. And so having determined that it is a qualifying work, then you have to assess who is the creator or the first owner. And that's very easy if you're an individual and you come up with something because it's you. But if you're employed to create that thing, then it's not necessarily you, it's more likely to be your employer. If you're commissioned by someone and paid to produce that, then you are the creator, the first owner. And that ownership stays with you, even if you're paid for it. And what usually happens, part of the purchase, there's an assignment that occurs and it transfers the agreed rights from the creator to the person who's purchasing it, because otherwise all they get in the purchase is the thing that's being produced. They don't have all the rights of reproduction and everything else that the copyright owner gets. And that's why they're very interested in those sets of rights. So yeah, and I think with the creatives, rightly so, they're focusing on what they're producing.
Absolutely.
And copyright is one of those things that hasn't really been out in the public domain until possibly the last 5 years, where people are very conscious of what rights they have and possibly what rights they don't have. So they are asking all the questions, and all the documentation is now sort of involving the assignment and the transfer of rights, which is quite useful, because that can be quite a messy conversation when years down the line you're having that conversation.
I think it's a really good point, because we do get a lot of queries about people who've done third-party work for other people, and you, like you said about direct employment and such like, and doing things as a contractor. There are subtle differences that you need to be aware of, aren't there?
Yeah, I mean, more people are being very good with their employment contracts, even short-term contracts, and they're covering it in IP clauses. So I would strongly urge people to very carefully read through that and make sure they understand what that means. But it usually comes down to, how are you employed? Is this your expected outcome? If it's not, then it's definitely a conversation you want to have with your employer, if your employer is ultimately going to be the beneficiary of this right. I mean, possibly it's stuff you're doing in your own time, but most employment contracts now cover that off too. Because if you do it in your own time, it's not necessarily yours. If it's being used from the knowledge you have in your day-to-day working environment, then again, there's the potential that this is actually your employer's IP.
So because there's no register and it's automatic for copyright, how do people evidence their ownership of a material?
Yeah, I mean, this is a real problem, because the UK has no copyright registration system. Other countries do.
The US
not all
do,
countries. The US do.
Yeah.
Yeah, they're very good. But please don't put something in an envelope addressed to yourself, which is usually the thing that's recommended, because in the hands of a barrister, if it comes to an ugly court situation, will very clearly show that that envelope arrived on a certain date, not the contents. There's nothing to say that the contents actually came through. And so I would say keep a good archive, even a software archive. It's all date stamped. What you need to show is the evolution. How did you come up to it? What were the factors? What was the timeline? How did it evolve? That's the other thing. Websites and things like that, the presentation of them, all covered by copyright. And most people, when you look at a website, you'll see the copyright word. Sometimes you'll see the C in the circle, which is a copyright symbol. Then you'll have this year. And then you'll have all rights reserved, which is your statement to say, I'm fully aware of my rights. All very good, except situations when that's not a brand new website. That's not something that's only just come into being this year, because when people do their due diligence and they're finding these websites, their interpretation of that statement is that's all brand new. So they potentially see things that are too close to what they're doing. They've clearly existed prior to this year's date, therefore they start ugly conversations. Whereas if you put the range, say your website's been up since 2020, so it's 2020 hyphen this year, or you just leave the hyphen open. The other thing to factor in, if your content was used prior to setting up a website, then that's also valuable if you had the same presentation on literature, on PR material and things like that. So you're able to pull that date earlier, but that's what you have to do. When you use a statement like all rights reserved, you're clearly telling the world you're fully aware of what your rights are. So put them out there. Make sure you're putting the right information out there, so that when people are doing their searches and trying to work out if this is a field that they can step into, they've got a better idea of third-party rights. Because without it, it's all a bit of a gamble.
That's interesting. So what you're saying, we talk about some of the benefit and importance for IP for business, but you think businesses should think about it early on? We always recommend businesses to think about it early on when they're setting up, as a startup. Would you recommend that too?
I think they have to think about it. I completely understand the priority is to get the business and running and getting sales and everything else.
Yeah.
But I think they would benefit from having at least a 5-year plan to work out what their goals are. Personally, I think if you haven't got a trademark, a minimum of your brand name set up within 3 years, then that's a primary goal at the 3rd year mark, because after 3 years, people are noticing you.
Yeah.
People will then start copying you. You need your defensive structure in place, or you actually starting to put it in place before you're so noticeable that you have sort of more than just your common law rights. Defending unauthorized use when all you've got is copyright infringement to fall back on, or unregistered trademark rights to fall back on, or even unregistered design right, the automatic right again that comes in with design. So if you're not going the registered design route, all of these are valuable IP because there isn't the necessary cost involved, but it highly depends on your record keeping, and that you can provide the evidence of your creation and everything else that significantly predates this other party. All the running is with you, all the cost is with you. The reason people go for intellectual property rights that are registered is that you've gone through a formalized process, you get a registration or a grant at the end of it. The courts are 100% behind you because you have an identified right that they can support you when you confirm that something adverse has happened or something unauthorized has happened. And it's on the other party to prove that they haven't done what's being alleged. And so usually you get things resolved a lot quicker if you have sort of formal.
It's a very good point. There
rights.
is no IP police. It is down to you, the business, and you as
Yes,
an individual
you really do
to
need to police
sort
your
it
own
out.
IP.
I think there's a good point about record keeping. Something we don't emphasise enough, Johnny, about record keeping for businesses and startups to think about, really, isn't it? I'm
Well,
going to
a
jump,
very
Johnny,
simple
you talk about
archive
infringement,
system.
but
It doesn't need to be really in depth, but you do need dates and sort of various things logged.
Yeah. You talked a little about infringement. Could you just talk us a little bit about the infringement and the sort of processes that are involved? About, I know you don't want to end up in court cases, but arbitration or how you sort of go forward with that kind of thing.
And like most people have heard of cease and desist and that kind of thing, but there may not be a general understanding beyond that.
Well, the first sort of contact has really got to be to put someone on notice of your rights. Usually people will be focusing on their own sort of business. They'll be using a brand or they'll have created a product, and then they'll notice that if not a competitor, but someone else in the market is using something that is either very similar or brings to mind what they're doing. And so first step should be always check that you've got your own arguments and all your date lines correct and you've got that in mind. Then I would recommend that you go and have a look and see what protections this other entity has got in place, because most infringements fall over if the other party has got either one of the recognized defenses, or which is usually saying it's not what you're alleging, or they've got their own protection in place and they're only operating under the remit of that protection. And then the third step is going to be contact. That could be a cease and desist. It could be business to business contact to say, quite concerned, just become aware of this is what we're doing. You seem to be doing something that's a little bit too close, and exploring the possibilities of finding out what they have, why they think what they're doing doesn't negatively impact on what the person who started that conversation is doing. And ideally, this can all be dealt with in conversation. It's at the point when that doesn't go far enough, or there's not open engagement with wanting to do it that way, that you usually hear things like cease and desist letters. These are the letters that classically are issued before court proceedings are triggered. And what they have to do is very clearly identify the issue, what rights are held, what rights have been sort of negatively impacted by the potential infringement, even to catalogue what the infringement is. Is it direct? Is it indirect? should it have been obvious that it would have been infringement? Because that's the other thing. I mean, if the party is fully aware of what one person has and then still does it, well, where's the get out of jail card in that, really?
Yeah.
And so it's quite difficult, because it's one of those things you can't go in with high sort of blood pressure. It's something you've always got to take a step back and think it through, because it's very emotional.
Yeah.
It's usually something that's very close, sort of important to the person who's triggering it. They've spent time, they've spent money, it's a big investment, and their immediate reaction, rightly so, most times is someone's come out of nowhere and they've taken what we've done. Now, you've just got to make sure you know as much as possible about both situations. Could there possibly have been a changeover of staff between the two parties? Could it be that someone was disgruntled and something? I mean, lots of things in the IP world can be simultaneously developing by different people who are independent of each other. And so you've got to make sure that no false claims are being sort of bandied about. And that's why I say that you really need to go in with a cool head, because if you are cool and calm and collective, there is always a solution out of it. If tempers fray, and that does happen as well, that makes discussions very difficult. And so that's when you engage people like me and my colleagues in the IP field, because once you get to the litigation side of things, it is done with a very, very cool head, because it's all, you say this, but the law says this. And so it's that waiting, continuously sort of saying, well, can you do this? Can you continue? Or what recourse are we looking for? It could be as simple as just stopping. It could be rebranding. There could be damages involved because of the actions where there's been losses and things like that. And there is the Intellectual Property Enterprise Court, which is the dedicated court set up in the Chancery Division for IP matters.
Right. Can you tell us a bit more about that? Because this is not something we sort of deal with very often. So.
Well, it used to be called the Patent County Court. And it was considered to be a bit of a misnomer, because everyone assumed that only patent cases went there. I mean, it did all IP. And so it had a bit of a rebranding exercise, I'd like to say 10 years ago, but I can't actually remember when it changed, because I've operated between the two of them.
Right.
And so the Intellectual Property Enterprise Court, or IPEC, as we all prefer to call it, has two streams. It has the standard stream and it has the fast track stream. It's slightly different which IP is held before each one. The biggest distinguisher is the amount of damages you can claim, because the standard stream is when you can maximize your damage return, whereas it's fixed in the reduced track, the fast track scheme. But the real benefit of IPEC is you don't necessarily have to have an IP lawyer or barrister doing it for you. It's set up so that anybody can use it. And most people do the fast track themselves. They might have support in filling in the particulars of claim that actually triggers it and everything else. But most people who are on the full track will do it with IP advisor support fully, and they might even have the litigators running it for them as well. But it all depends on what's involved. And that's usually after communication has broken down, whether that's sort of B2B or whether it's the letter writing just hasn't got the outcome that is being sort of sought. So it isn't something that people trigger straight away. That tends to come afterwards.
Yeah, that's interesting.
So everything that you've discussed today has been talking about IP within the UK kind of remit. What are the options for people that may be looking to protect their IP internationally?
Okay, well, IP tends to be country specific, is the first thing, and trademarks, because most people have got an internet presence or social media presence, it has instantly more sort of coverage than just the UK. Trademarks and designs are quite easy, because you file in your home country. 6 months later, or within that 6-month window, you are able to make a Paris Convention filing. And that means that anyone who has signed up to the Paris Convention, and that's the majority of countries, you can file in any of those countries. As long as you're in that 6-month window, it will be as if you filed simultaneously with your UK filing. And that's when you claim priority from something.
So that's not,
It's
not just European countries, that's...
Oh, no.
Cool.
It's most. The key thing is, are they a Paris Convention country? And you can go onto WIPO and you can actually pull down the list of countries that applies to.
Lovely.
And so that's the majority of countries. So most people will do that. Designs are the same. They've got the 6-month period in order to do that. Patents, you do it slightly differently because you file in your home country. In the first 12 months, it's as though you have pending patent protection everywhere. And at the 12-month stage, you have to decide what's happening next. So when you file the application, you'll have requested a search and examination. And within that 12 months, you'll have received that back. So you've got a really good idea of what's out there and what you have to do. But in order to prevent your patent application only achieving grant in the UK, you have to make a big decision prior to, but no later than the 12-month deadline, because this is when most people branch out. At that point in time, they've got everywhere pending. Most people then jump into something called the Patent Cooperation Treaty, or the PCT, and that extends their rights in those pending countries for a further 18 months. So 30 months from filing, they've still got pending rights in 150 plus countries. And for everyone in that set, at the 30-month stage, that's when they have to make another decision about which countries they're going to come down to, because again, that's another cost milestone. Now, anyone who is not, any country not in the PCT side of things, at the 12-month stage, if those countries are of interest, you have to trigger those before you expire on that 12-month deadline. So it's a way of making sure and you have to make that decision in your first 12 months. So whilst you're evolving your invention, you're trying to get people to invest in you, you're also having to make that really difficult decision of where do I limit coming out of this 12 months? And that's a really horrible decision to make.
It's a tough call to make at that stage, isn't
it? Yeah. Well, Melanie, you've just some really fascinating stuff. I'm going to ask you something slightly lighter. How did you become an IP attorney, and what was your did you fall into it? Was it your childhood dream? What was the kind of...
Oh, no. It was very odd. So my dad was an engineer, and he said I would always enjoy engineering, typical daughter. Of course, I did something else. I went off sailing, didn't want to do that at all. No daughter likes their dad telling them what to do. But bizarrely, the sailing was a really good thing. I was the cookmate on an Edwardian gaff schooner for a couple of years, which was absolutely the best thing a 19-year-old could do who didn't really know what they wanted to do. I met lots of people from lots of different industries. And because of that, I then went back and did an apprenticeship. I did an indentured apprenticeship with the MOD, got lots of exposure on lots of things. Bizarrely, it was only towards the end that I got exposed to the IP side of things, because, of course, as you'd imagine, crown use and lots of things like that, there's lots of IP that the MOD and the forces would naturally rely on. But when I came out of that, mainly because I got married, and it doesn't really help if you're in two different locations when you're married, I took up something with my local university. I did a technology transfer scheme, and the benefit for me was that I got an MSc by research. I didn't pay for it.
Wow,
yay.
That's good.
And I worked for a local company during the day. So it was a toy company or an educational company, and we just used robots to remodel how the classic physics experiments used to occur. And I think when I was at school, that was little sort of trolleys and ticker tape and everything else for the laws of motion. We used robots, and it was much more fun. But that was the time when the Lego Mindstorms was all over the place. So everyone was interested in robots. But that was a very good thing, because it was a university partner, it was a company partner, and there were the individuals. And the main discussion occurred on a regular basis was, whose IP was it?
Mhm.
And so suddenly I was immersed in IP, and my supervisor at the time said that he thought I would really enjoy it. And so I got this sort of got bitten by the bug, because the more I tried to find out, the more I couldn't find out. Once you're in the IP field.
Yeah.
Trying to get in, if you're not conventional, is very, very hard. And all I would say is just persevere, because I wasn't Oxbridge. I'd done other things before, sort of doing degrees and things like that, because my apprenticeship, essentially, I went off and did my degree, and they sort of supported me in summers and things like that. So it was a good milestone. Most people in the IP side of things will have a degree. If you want to do patents, then it has to be engineering. So I did an engineering degree, electronics. But it could be mathematics is sufficient. Chemistry is a really popular one on that side of things. But mechanics, I mean, it's the logical thought processes that are required. You learn in training how it all goes together and everything else, which is quite good. I sort of worked for one firm for a couple of years. My last firm was 17 and a half years, and I've been where I am now for 3 years. And you get to know lots of people in the industry, and it's a really enjoyable. It's sort of, the law is one thing, and I really enjoy the law, but it's the backstory. It's what sort
I
of
can tell from you, because when we deal
motivates
with you, you're
people.
more interested in the people, the customers, than the legal side
Because,
of it.
well, then I can tailor sort of the advice that will have sort of
absolutely.
the sort of main traction for them.
Because there is no one size fits all with IP,
No,
is there? So
no.
you do have to have the backstory, don't you?
Yeah, it's very
That's
good.
really
I
interesting.
quite like it.
Well, we're coming to the end of our theme. I'm going to throw you one more under the bus with one more question. This is a really easy one. AI, end of the world or a business opportunity? That's your last question.
Well, anything that's new, I
Yeah.
think everyone should get in at this stage. I mean, most things when they're new, you don't want to necessarily buy it until all the bugs have been sort of ironed out. But the thing is, nobody really knows where AI is going. There's lots of things happening on the IP side of things. Because a lot of people are desperately sort of rejigging all their trademark protection, because of course they haven't got the software elements supported. So lots of shops haven't got Class 9, which covers software and apps and things like that. And to prevent other people using their branding in the AI sense, then suddenly there's a lot of this going on. But there's also a lot of litigation to go after them when they haven't got that in place either. So I think keep your eyes open, see what's good, what's bad. And if it's something you can pull into your business, then in at the grassroots is probably the best time to do it, because this thing is going to evolve. And when things evolve, they get expensive.
Yeah.
So I'm
the early
undecided.
days. It's
I
still
have to
early
be
days,
honest.
isn't it? Really early
Yeah.
days for a lot of this. Yeah.
Yeah.
Okay.
I
Well, that
don't
was
know
very
if it's a
good.
good thing. I think most AI that I see on the IP side of things still needs a person to come in and look at it.
Yeah.
I'm not convinced it's at a position where you can just press the button and live with the result, because I don't mind it doing a lot of interpretations, a lot of data sorting and things like that. I just haven't seen other benefits that I would be interested in other than that at the moment. That's not to say they're not being developed.
No. Watch this space, really. Well,
Yeah.
thank you so much, Millie, for joining today. It's been absolutely fascinating. I hope you'll come back next year and do another one, because I think there's a lot more to talk about in the IP.
No. I'm very happy to come. I always worry that I'm talking too much, so I'm very happy to come.
No, it's absolutely fascinating, especially for us who work a lot with IP. It's very, very interesting to hear a professional, talking about it. But well, thank you very much for joining us for this podcast. You can subscribe to For Every Bright Idea on Spotify for podcasters. Next time, we hope to have Emily from the Morton Mardle Micro Pub in Norwich talking about how she set up in a business. But for this time, thanks very much for joining us, and we'll see you next time. Thank
Always a
you.
pleasure.
Bye-bye.
Bye-bye.